Protests are expected to continue across the country today following the leak of a Supreme Court draft decision that would overturn Roe v. Wade. Thanks so much for joining us here on Denver 7 Plus. I'm Jason Grenauer. This afternoon, we continue our 360 in-depth coverage on the potential dramatic shift in our abortion laws. We begin with a look at the historical view of Americans on abortion. Gallup has been keeping track of abortion sentiment since the mid-70s. Public opinion has ebbed and flowed over the decades, but generally, acceptance of abortion has grown while opposition has shrunk. The latest Gallup poll shows 48% of Americans believe that abortion should be legal under some circumstances. 32% believe it should be legal no matter what, and just 19% want to outlaw it completely. Let's take a closer look at Colorado's situation. With or without Roe v. Wade, Colorado allows abortions. That right was codified into law this past legislative session. But that doesn't mean that things can't change in the future. Denver 7 political reporter Megan Lopez looked into the policy details and the efforts being made for change from both sides.
It was short, the celebration by abortion access advocates, when Governor Jared Polis signed the Reproductive Health Equity Act into law. Short because one day shy of 1 month later, a leaked U.S. Supreme Court draft decision likely means the end to Roe versus Wade. But this moment and that decision is exactly what these advocates were bracing for.
It's why we as legislators here in Colorado took proactive steps in order to ensure and protect reproductive health care options in the state of Colorado.
But that was a statutory change, meaning lawmakers or voters could undo it with a simple majority vote.
Very much linked to kind of the political future of the state, of who's in control. So the more secure option is to move to a constitutional amendment.
Which is exactly what abortion access advocates are aiming for next. Cobalt is one of a few groups working on a ballot question to codify that access into the state's constitution. It would also change the state's funding laws.
In 1984, we passed an amendment that said no state funding can be used for abortions. So we really think that this is a negative issue and it needs to be fixed.
But that ballot question likely won't come until 2024. This year, anti-abortion groups are working on a measure of their own for voters. Initiative 56 would ban abortions at all stages of pregnancy except for a few rare circumstances like to save a mother's life. Supporters are now in the process of collecting signatures to officially get it on the November ballot. Juliana Day.
It was such a great way to assess what the feelings of the people in the state.
Ran an unsuccessful 2020 ballot question to ban late-term abortions. She knows the uphill battle ahead for this year's initiative. Still, she's hopeful.
This creates a lot of excitement in the pro-life community, no doubt about it.
She's not sure this ballot question will be successful, but says it's about educating people.
So little by little, we're changing the hearts and the minds of the people.
That ballot question and the Supreme Court decision also come during an important midterm election year.
There's an argument that this would mobilize both progressives and conservatives.
And there's calls for Congress to act, but again, it would depend on who's in control after the midterms. Megan Lopez, Denver 7.
We know abortion is protected in Colorado, but let's take a deeper dive and look at what other states would do if Roe v. Wade is overturned. 13 states have so-called trigger laws. Those laws would automatically start the process to make abortion illegal again if the high court allows it. In 4 of these states, abortion bans would immediately go into effect once Roe is overturned. 5 states have pre-Roe abortion bans that were invalidated with the original ruling. If the case is overturned, they could return, but it's unknown how they would be enforced. 11 states would ban abortion earlier than fetal viability. That's 22 weeks or earlier. If Roe v. Wade is gone, those states could restrict abortions to before 20, 16, or 6 weeks. Altogether, abortion would likely be banned or heavily restricted in 27 other states. Now let's bring a little more depth into the impact a decision like this could have on the future. Denver 7's Rob Harris spoke with experts about what this could mean for things like same-sex marriage, interracial marriage, and access to contraception.
To help us answer these questions, we talked to 2 experts, Jennifer Hendricks, a professor of law at the University of Colorado, and Joshua Wilson, a professor of political science at the University of Denver. So question 1, could this ruling lead to the overturning of other Supreme Court decisions? Both of our experts say yes.
The right to abortion is part of a modern edifice of constitutional rights that are usually sort of grouped under the general concept of the right to privacy. The original modern case in that line was a case called Griswold versus Connecticut, which struck down the criminalization of contraception. And also that is the same line of cases that protects the right to marry, which includes both Loving, the interracial marriage case, and Obergefell, the same-sex marriage case. The foundation for all of those precedents has been yanked out.
Some on Twitter are correctly pointing out that Justice Alito in this draft opinion specifically says it's not intended to go after decisions other than abortion. But our experts say that's not how Supreme Court decisions operate in the real world.
He tries to cordon off what he's arguing and to say this only applies to Roe and can't apply to other fundamental rights. That's not the way that law works. Future lawyers in future cases can use the same sorts of arguments that he's laying out here to go after other established fundamental rights.
Now to question 2. What could this mean for same-sex couples married in Colorado? In some ways, that remains to be seen. Colorado voters in 2006 approved a constitutional amendment that defined marriage as being between one man and one woman. But a U.S. district court struck down that ban in 2014, about a year before the Supreme Court decision in Obergefell v. Hodges, which legalized same-sex marriage across the country. Because the district court's decision leaned on the federal constitution, Professor Hendricks says an overturn of the Supreme Court's decision could resurrect state bans, including Colorado's.
In that sense, Colorado would need to act affirmatively to protect the right to same-sex marriage if there were, if Obergefell were overruled.
We've covered multiple perspectives and angles of the abortion debate over the course of the last few days. You can find all of our 360 in-depth coverage right now. That's up on thedenverchannel.com.